Greetings, entrepreneurs, inventors, authors, and other creative types. This is Professor Folise again, and we're here today to talk about due diligence with respect to patents, trademarks, copyrights, and trade secrets. Does your company have an obligation to search for prior arts for patents? Or do you have an obligation to look and see whether you're infringing somebody else's trademark? Or more particularly, do you think you could get a patent or a trademark? Is there something you could do on your own before you start down that expensive process to avoid maybe a misstep? And of course, the answer to these questions is yes. So with respect to due diligence, there are two factors that you should consider. One, are you infringing somebody else's rights? And two, can you get some rights of your own? Let's move back to the first question. So with respect to patents and due diligence, there are three things you can do that are very inexpensive. If you're considering making a product that competes with someone else's products, then the first thing to do is to look at the actual products themselves. Patent owners have a big incentive to put their patent number on their product. If a patent issues and somebody makes products under the patent but doesn't put the patent number on the product, they can't collect damages for infringement. So almost every patent owner will put their patent number on their product. And you can look at that patent number, go to the patent office website, and bring that patent up and take a look at it. And if it's totally irrelevant, you know you don't have a problem. And if it looks really close, maybe that's the point at which you can get a patent attorney involved. Here's another thing you can do. You can go to the same patent office website and do an assignment search for your competitors. Let's say you work in an industry where the number of competitors is fairly limited, maybe only half a dozen or so. It's possible at the patent office to look for all the patents that are owned by that competitor or those competitors. Now, you don't have to go back any further than 20 years because utility patents only last for 20 years from the filing date, and design patents only last for 15 years from their issue date. So you can limit your search that way to keep the number of patents that you discover low. Again, go through them, and if they're irrelevant, don't worry about them. But if they look kind of close, that's the time to get a patent attorney involved. What about, can you get a patent? Well, you already got a collection of some prior art that you're aware of from looking at patent numbers on similar products and looking at patent owners by your competitors. You can do some subject matter searching by using word association, but a better idea is to take the patents you already have and search forward and backwards from that. When you get to the patent office website, you'll see there's a text version of that patent which has hyperlinks with respect to all the patents that the patent office cited in considering whether to get that patent to issue, as well as the patent itself. You can look and see if other patent examiners have cited that patent against somebody's patent that was filed thereafter. And the obverse is true for things that go backwards in time. So that's a very easy way to get a good look at the prior art. And you might realize there are certain technological areas that are blocked, but other ones that are open, and you can push your product in that direction. What about trademark searching? Well, with respect to avoiding infringement, if you're the junior user of a mark that will confuse the public into thinking that your products come from a senior user because of the similarity of their trademark, that's an infringement problem. So you'd like to take a look at the federal and state trademark office registers to see if anybody certainly has the same mark used on similar products. Those are very easy searches to do. But there's something else called common law rights. Even if someone doesn't have a registration, if they merely use the mark on a product and ship it in commerce, they're generating trademark rights. So how do you find out about that? Well, an easy way is to simply use a generic search engine to put that trademark in there and see if there's any products sold under that mark. And you can decide for yourself whether they're substantially similar in sight, sound, and appearance, whether the channels of trade are similar, whether the goods are similar, whether the consumers use a lot of care or a little bit of care in picking the products. And those are the factors that a jury would take into consideration in determining trademark infringement. Obviously, for a more thorough and reliable opinion, you'd want to consult an attorney that specializes in those things. What about copyrights? Well, with respect to avoiding infringement, it's real easy. Just don't copy. Now, certain copyrights are expired. We know they only last for the life of author and 95 years if it's an individual owner, and 75 years from the date of publication if the copyright's owned by a corporation. So all that stuff's free to copy. If you don't know how old it is, the safe thing to do is presume it is copyright and don't copy. Frequently, you'll see a copyright notice on products. C in a circle, followed by the year of publication and the name of the copyright owner. Copyright owners frequently do that because they're willing to license use of the copyrighted material, maybe sell it, or grant you permission without remuneration. So how would you find out their contact information? Well, if the copyright notice is there, you know who the owner is. You can go to the Copyright Office website and look to see what registrations they own, find out, and the copyright registration certificate itself will have contact information so you can get a hold of the copyright owner. What about trade secrets? What kind of due diligence do you have to do to avoid infringement? Well, don't use anybody else's confidential information. And if you have an employee that's coming on board with your company from a competitive company, make sure during the interview process and the hiring process that that employee understands that they can't use any trade secret material that they acquired while at the previous employer when they're working for you. What about getting a copyright? Well, as we said before, merely fixing the work in a tangible medium gives you the copyright. You don't need to do anything more to that, and so you really don't need to do any searching. Certainly, if you're copying from somebody else, you're not an original author, and you're not going to be entitled to a copyright. So, in a nutshell, that's the due diligence that every company should do with respect to avoiding infringement and finding out whether or not they can get a patent or a trademark. If you want to know more, consult a patent attorney or trademark attorney. And if you want to find out what kind of free resources are available for you to do all this searching, make sure you tune into our next video. Live long and prosper.